Welcome back to another episode of Am I the Asshole? On this week's episode, we are going to be discussing what constitutes the need to modify child support and or alimony. Dear Wolf and Shore, my ex and I have 2 children together and have been divorced for a few years. She now lives with her boyfriend. They tend to take vacations frequently throughout the year, and I am a bit frustrated by this. Am I the asshole if I file a motion to decrease my child support? Sincerely, Even Steven. It sounds like your kids are living a pretty amazing life. It also sounds like you might be a little bitter about the fact that your money is being used to fund some vacations for your kids with your ex and her new boyfriend. So let's get into it. In order to dissect the dichotomy of alimony and child support and what it should be used for, we need to back it up a little bit to understand its purpose. The intention of alimony is to provide support for an ex-spouse on an ongoing basis based on the fact that there were both financial and non-financial contributions made during the marriage, which required for that person to perhaps not make as much money as the other spouse. As a result, the other spouse is going to be required to then compensate them through divorce. Child support, on the other hand, is meant to very literally support your children. There are no restrictions in the state of Connecticut as to how the child support needs to be spent. In other words, it could be spent on vacations, it could be spent on food, it could be spent on housing. The intention behind it is to provide for a financial settlement which would allow for both parties to live in a very similar household financially, and also to ensure that no child would be left without in either of the households due to financial constrictions. So, with that understanding, back to your question, either party can actually move to modify either child support or alimony post-judgment if there's a substantial change in circumstances. When we're talking about a substantial change in circumstances, a lot of factors are taken into consideration. One thing that can be considered is whether or not you're both making the same amount of money that you were making at the time of the child support award. If either of you is making more or less, then that could amount to enough to make for a substantial change in circumstances in which the court would modify the child support order. In relation to your specific question, let's just say that her boyfriend is simply paying for her and your child to go on a vacation. That's not going to affect child support. And as I said earlier, you can't dictate what she spends the child support money on. So if you're bringing a motion to the court just based on the fact that your ex has gone on a few vacations with your child, well, then there's a chance that you could be the asshole. And the court may see it that way as well. Now, if we were talking about alimony, if your ex's live-in boyfriend was paying for the household expenses and you could prove that, keywords, then you might have the ability to modify the alimony award. But that's very different than child support. What I would recommend is that you consult with an attorney so that you can weigh out your options. You need to be honest with your attorney, and you need to explain to them exactly what's going on in your situation so that they can advise you appropriately and make sure that you're on the same page moving forward before you file any motions in the court. So, what do you think? Make sure to leave a comment below and subscribe to our channel. If you have any questions regarding a family law matter here in the state of Connecticut, schedule a call with our team and set up a consultation. In less than an hour, we will set up an outline as to how the process works and answer any questions you may have. I'm Kristen Wolf with Wolf & Shore Law Group, and we look forward to helping you.